You can buy like elite luxury birth tourism packages. It is crazy.
Only a stupid nation would allow this to happen.
When Trump announced he's asking the Supreme Court for a rehearing on birthright citizenship, the one that just came down last week, the internet's reaction was basically the same in one sentence. You don't get a redo at the Supreme Court. Everybody said it like it was obvious. It's not true. There is a real process for this. It's sitting right there in the court's own rulebook. Most people have just never heard of it because in almost 70 years, it's only actually worked one time. So let's do this right. No hype, no dismissal. What the process actually is, how it would have to play out, and an honest look at the odds. I'm Kelly Jackson, and this is Still Not Canceled. If you want the actual process explained instead of just a hot take, hit like and subscribe now because this channel is where we find out how this stuff really works, not just how to react to it. We question everything, especially the narrative. So let's get into it. So a quick timeline so we're all on the same page, as I'm sure most everybody has heard, but just in case you haven't. June 30th, 2026, the Supreme Court rules 6-3 in Trump v. Barbara, striking down President Trump's executive order that tried to end birthright citizenship for children of parents who are here illegally or temporarily. The court says the 14th Amendment protects them too. Within days, this story breaks.
You can pay $3,950 if you want to have birth naturally, make your child a U.S. citizen.
Are you kidding?
Your foreign board C-section, $5,525. I spoke with Ken Paxton on this, and he showed me pictures where there are houses in Texas that look residential. So it could be your neighbor's house, and you go inside the house, and there are rows of bassinets where Chinese women are coming, giving birth to a child, then going back to the Chinese Communist Party, educating their child there, and they have U.S. citizenship, which could amount to more than 1 million new voters in this country over time.
Only a stupid nation would allow this to happen. They also have a website, havemybabyintexas.com. By the way, this big border advertisement right there is miles away from the border. So their audience are people that are crossing back and forth. And by the way, if you think it's just Mexicans, no, that's just a checkpoint right there. People are traveling from all across the world to come to Mexico to go pregnant. They could have their baby here in the state of Texas. And, you know, as a result of that, their kids are going to be American citizens. Congress has to codify this law.
Yeah, and
that's what they need to do.
They've taken this billboard down and the website. And this is obviously catering to a Spanish-speaking audience. The ones that I mentioned were separate and apart. And Abbott is prosecuting those, and those are Chinese birth tourism.
I think we need the federal government to go over social media sites, not just billboards. Billboards are easy to spot, obviously, by their definition. But what about what other advertisements are in other countries, giving them a pathway? We saw that with Come to America. It's never been easier during the Biden years. Now it's Come to America. I didn't know they even existed. I'm stunned by that. Oh, yeah. Stunned by that. As if like we need to make $5,000 by giving birth here and then giving you citizenships to boot.
Right. They have pictures of pools that these women can lounge by. You can buy like elite luxury birth tourism packages. It is crazy. And then Tommy Pigott at the State Department was telling me that they caught fraudulent documents coming from South Africa, North Africa. There have been more than 400 cases out of Europe in just 1 year alone. It is worldwide. And do you think the founders, or the framers, I should say, of the 14th Amendment really intended for 2 billion women in the world to have access to have a baby on our soil and boom, you're a citizen?
Do you think Democrats would be against this?
So a Texas hospital allegedly running billboards in Mexico advertising birth packages. Reports put the price around $4,000 with citizenship as the product. Governor Abbott ordered an investigation, and within about a week, President Trump posted that he's filing for a Supreme Court rehearing, calling the ruling a miscarriage of justice and saying American citizenship is not for sale. That's the real news. So now let's talk about whether rehearing is even a legal move, because it is. Buried in the Supreme Court's own rulebook is Rule 44, rehearing. It says a losing party can file a petition asking the court to reconsider a decision. Here's the catch, 3 catches, actually. Catch 1, the clock. You've got 25 days from the ruling to file, and that's it. Catch 2, and this is the part nobody really explains. The rule says rehearing will not be granted except by a majority of the court at the instance of a justice who concurred in the judgment. Translation: it's not enough for President Trump's lawyers to file paperwork and make noise. One of the 6 justices who already voted against him has to be the one who goes to their colleagues and says, wait, let's look at this again. The losing side doesn't get to force it. Someone on the winning side has to have second thoughts. Catch number 3. The court has to actually agree by majority vote to grant it. Filing the petition guarantees nothing. It just gets you a chance to be read. So, real mechanism, real rule, sitting in the actual rule book. That's the hope part. Now here's the realism part. According to Georgetown law professor Steve Vladek, the Supreme Court hasn't granted rehearing of an argued case since 1965. And even that one was just a technical fix, and it wasn't a reversal. The last time the court actually flipped a decision through rehearing, changed the outcome, was 1957. That's the only time it's ever happened in the court's entire history. One of the legal experts covering President Trump's actual petition called it, quote, a non-starter. I'm not telling you that to shut the conversation down. I'm telling you that so when I show you the one time this worked, you understand exactly how big of a deal it actually was. 1956, 2 American women, wives of U.S. servicemen stationed overseas, are convicted by military court-martial, not a civilian jury, for killing their husbands. They appeal, arguing that they should have gotten the same constitutional protections any American gets, a jury trial. The Supreme Court rules against them. Case closed, right? Except their lawyer, a guy named Frederick Bernays Weiner, files a rehearing petition so thorough that legal historians still study it. 5 months later, the court agrees to rehear the case. They re-argue it in February of 1957, and in June of 1957, the court reverses itself completely, 6-2. Holding that the Constitution travels with American citizens no matter where the government acts against them. Here's the detail that makes this story. No justice retired. No new justice joined. It was the exact same 9 people. They just changed their minds because the second argument was that good. That's the bar. Not the public was mad, not the president said it was wrong. A legal argument so strong it moved sitting justices off of a position they'd already committed to in writing. Here's why this specific case is more interesting than a flat no chance. The 6-3 vote wasn't 6 justices agreeing on one reason. Chief Justice Roberts wrote the majority opinion, joined by Sotomayor, Kagan, Barrett, and Jackson, ruling that the 14th Amendment protects these kids, period, following the court's 1898 ruling in Wong Kim Ark. Justice Kavanaugh did not sign on to that opinion. He wrote separately. His reasoning was narrower. President Trump couldn't do this by executive order because Congress already passed a law on this. But Congress itself, Kavanaugh wrote, could pass a new law creating exceptions. And in his view, that would be constitutional. That's the real difference. Roberts' opinion says this is a constitutional guarantee, full stop. Kavanaugh's opinion says the president can't do it alone, but leaves the door open for Congress. Reporting on the case has also suggested that on the pure constitutional question, not just the outcome, but the reasoning, Kavanaugh actually lined up closer to the 3 justices who dissented entirely than to Roberts' majority. So technically, under Rule 44's own language, Kavanaugh is a justice who concurred in the judgment. He's eligible on paper to be the one who could raise this internally. Nobody else who ruled against President Trump has shown anywhere near that kind of daylight from the majority's reasoning. I want to be straight with you here. Being eligible means almost nothing by itself. It just means he's not automatically disqualified the way the 3 dissenters are, since they voted the opposite way. There's zero public evidence that Justice Kavanaugh wants to reopen this. His opinion already tells you what he thinks. So what would it take? Not the billboards themselves. This is outrageous isn't a legal argument, and courts don't work off of outrage. A real petition needs a hook. Either a genuinely new legal question the court didn't address, or a fact that the court's own reasoning actually depended on that since turned out to be wrong. And here's the tricky part for President Trump's side. This ruling was decided on text, 1860s congressional history, common law, and precedent, not on a cost-benefit weighing of consequences. That matters because if the ruling doesn't rest on the risk of abuse is low, then proving the risk of abuse is real doesn't actually undercut the ruling's logic. It's a different kind of argument entirely. There's also a trap here worth knowing. Thomas already wrote a dissent using the same historical materials and reached the opposite conclusion. If a rehearing petition just reruns Thomas's arguments, that's not new. The court already had those arguments and rejected them 6-3. Rule 44 specifically requires grounds not previously presented. Recycling the dissent is the single weakest way to try this. So, a serious petition would need something genuinely not yet in the record. Not a strong opinion, not a Truth Social post, an actual new legal thread. So here's where that leaves us. No hopium, but no dismissal either. Rule 44 is real. The 25-day window is real. And this particular ruling has a real documented crack in it that most rulings don't. Kavanaugh's separate opinion. That's not nothing. But the honest odds are still what the history says they are. 1 reversal ever. 1 rehearing of an argued case since 1965. And the specific argument being floated right now that billboards prove the risk was real isn't obviously the kind of new legal ground that Rule 44 is built for. Real process, but long odds. That is the whole story. And you now know more about how the Supreme Court actually works than most anyone reacting to this online. If this saved you from getting talked into either side's hype, that's the whole point of this channel. If this saved you from getting talked into either side's hype, that's the whole point of this channel. So please hit subscribe if you haven't, drop a like, and I'll see you in the next one. I'm Kelly Jackson. This is Still Not Canceled, and we'll talk soon. Bye-bye.